Welcome back to Mimi Leaks. Before we begin, please note that this episode contains discussions of sensitive topics, including abuse and misconduct, which may be triggering for some viewers. Viewer discretion is advised. Today, we're concluding our 4-part series on the Ringboys lawsuit brought by John Does 1 through 5 against the World Wrestling Entertainment and the McMahons. This portion of the complaint breaks down in detail the abuse and mistreatment each John Doe allegedly endured as minors during their time with WWE, and thereafter, we'll get to the causes of action and closing arguments. Please be sure to subscribe to the channel for more, and thank you for joining us on this journey. Now let's wrap up the case. 3. Phillips abused the plaintiffs and caused lasting injuries. Many of the following paragraphs contain descriptions of criminal acts to underage boys, so I will be summarizing these specific paragraphs. Just a heads up. A. John Doe 1. John Doe 1 met Phillips when he attended a WWE event with his cousins sometime between 1981 and 1982 at age 13. Phillips approached Doe 1, lured him into a private room in the arena, and assaulted him. He gave Doe 1 a front row seat, and at the end of the night, he obtained his phone number. A couple of weeks later, after that first encounter, Phillips called Doe 1's mother, and, assuring his safety, picked up Doe 1 to dine out. After their meal, Phillips lured Doe 1 into his hotel room, assaulted him, drove Doe 1 home, and handed him $80. The next time WWE came to the Springfield Civic Center, Phillips called John Doe 1 and invited him to the event. Doe 1 asked if he could bring his cousins, but Phillips said no. Phillips met Doe 1 outside the arena and hugged him. Phillips then took him and 2 other young boys inside and introduced them to several different wrestlers. Phillips took the 3 boys around the arena, including the ring area, before taking them to a private room with a bathroom, where he assaulted the boys. Phillips then gave the boys front row seats next to the announcer's table where he worked. John Doe 1 later attended a WWE event with Phillips at the Spectrum in Philadelphia. A boy of similar age from Boston also attended. In a private room at the arena before the event, Phillips took Doe 1 aside and SA'd him. After the event, the boys went with wrestlers, Phillips, and other staff on a bus to a hotel and to a separate hotel room, where both boys were assaulted at various times through the night. Doe 1 was dropped off by Phillips the following morning, given money, and told to stay quiet. The boy from Boston left with Phillips. Phillips called Doe 1 regularly and weeks later took him to eat. After, Phillips questioned Doe 1, made advances, and eventually took him to a hotel where Doe 1 was SA'd, given money, and told to keep quiet. On a later date, Phillips brought Doe 1 to another show in Baltimore, Maryland. There, he SA'd Doe 1 and 3 other boys, the SAs becoming more violent in nature. And back on paragraph 75 in the complaint. Thereafter, Phillips continued to call John Doe 1, but he was now very afraid of Phillips and told him he did not want to see him again. In total, Phillips abused John Doe 1 approximately 7 or 8 times in a 12 to 18 month period. Phillips also gave John Doe 1 alcohol multiple times. Since Phillips' abuse of him as a minor, John Doe 1, has suffered from mental and emotional distress. John Doe 2. Phillips met 13-year-old John Doe 2 in 1984, like Doe 1, outside an arena hosting a WWE event, where he lured Doe 2 into his dressing room and assaulted him. Phillips assaulted Doe 2 at other WWE events as well. In hotel rooms, the SA would also occur, where Phillips would set up a video camera to record what he was doing. The assaults would often take place under the guise of wrestling, in which Phillips would become violent, as seen in this photo of Phillips and Doe 2. John Doe 2 witnessed Phillips similarly abuse other young boys. Phillips often traveled in his own vehicle with the boys following the WWE ring crew. They would eat together at restaurants and stay with Phillips at hotels. It was common knowledge that within the WWE that Phillips was traveling around and with young boys, and that he had a young boy foot fetish. When backstage at wrestling shows, the boys were sometimes asked by the wrestlers and security who they were, and they just had to say, "I'm with Mel Phillips." WWE wrestlers, security, and other employees often saw the boys helping set up the ring, and they would also see him coming to the events and leaving the shows with Phillips. Phillips psychologically manipulated John Doe 2 in an effort to control and dominate him. John Doe 2 attended numerous wrestling shows with Phillips from approximately 1984 to 1989 in at least the following states: Maryland, Pennsylvania, Rhode Island, Massachusetts, Connecticut, and New York. John Doe 2 was abused by Phillips in all of these states and multiple times, and then was transported across state lines as well. After being transported across state lines, Phillips took photo and or video of the abuse he inflicted upon John Doe number 2. Since Phillips' abuse of him as a minor, he has suffered from mental and emotional distress. John Doe number 3, which is C. John Doe 3 met Phillips in the mid-1980s when he was approximately 14 years old. When they met, Mel explained who he was, asked if he liked wrestling, helped him meet a couple of wrestlers, and offered to take him to Philadelphia for a show at the Spectrum. Phillips would at times pick him up and drive him to Hamburg, Pennsylvania, where WWE did tapings. They were always alone except one time when there was another boy with them. John Doe 3 traveled with Phillips to a show in Philadelphia where it is alleged in detail that Phillips assaulted him at various times throughout the night. Phillips abused him in similar ways at most, if not all, of the subsequent wrestling shows he attended with Phillips. The following are photos taken by John Doe 3 of Mel Phillips during one such show, which highlights the closeness to the ring and Phillips that the Ringboys like John Doe 3 often found themselves. After a few months of attending wrestling shows with Phillips, a wrestler approached John Doe 3 and said to be careful around him. John Doe 3 says when traveling for WWE events with Phillips, the essays would start as soon as the hotel room door was shut for the evening. Phillips sometimes gave Doe 3 soda in cups, and that soda tasted different than normal soda, and when Doe 3 would ask about it, Phillips just said, "It's okay." Doe 3 felt lightheaded after drinking the soda, and shortly thereafter, Phillips would begin abusing him as described. Doe 3 attended at least 12 wrestling shows with Phillips from around 1984 to 87, at least in the following states: Maryland, Pennsylvania, and others. Doe 3 was transported by Phillips across state lines. After being transported across state lines, Doe 3 was subjected to the abuse described herein, along with Phillips taking photo and or video of the abuse. Since Phillips' abuse of him as a minor, he has suffered from mental and emotional distress. John Doe 4, D. John Doe 4 was around 13 years old when he met Phillips in approximately 1983 to 1984. John Doe 4 met Phillips along with neighborhood friends who were also minors. Phillips frequently drove to the street where they all lived, picked them up, and drove them around Philadelphia. Confidential witness number 1 is a sibling of John Doe 4's friends. Confidential witness number 1 saw Phillips multiple times drive onto their street, watch the boys play, and show them all WWE championship belts that he kept in his car. Phillips then drove the boys away, and they sometimes returned drunk. Other times, witness 1 knew that the boys stayed overnight in hotels with Phillips. Phillips took John Doe 4 to a WWE event at the Capitol Center in Landover, Maryland. After the event, Phillips supplied John Doe 4 and other boys with alcohol and took them to a hotel, or perhaps a motel. Doe 4 vomited, so Phillips took Doe 4 into the bathroom where he was essayed. Phillips also took Doe 4 and his friends to several WWE shows at the Spectrum. Doe 4 and his friends worked for Phillips on the ring crew at those events. Several times, when the boys arrived at the Spectrum, they simply told security that they were meeting Phillips and security let them in. Below is a screenshot of Doe 4, with the red arrow, seated in the second row, who attended the show with Phillips, also pictured below, and obviously along with other ring boys. At WWE shows at the Spectrum, Phillips inappropriately touched Doe 4 and other boys under the guise of wrestling. Phillips often did these things to neighborhood friends in the locker room in full view of wrestlers and Pat Patterson. Everyone would joke, "Oh, Mel's getting your toes." Patterson was frequently around the ring crew and at least once paid Doe 4 to run an errand for him. Vince McMahon also checked on the ring when Doe 4 and other ring boys were working on it. At one WWE event, Joey Marella, a former WWE referee and son of wrestler and announcer Gorilla Monsoon, told Doe 4 and his other age friends the following: "Watch out what you're doing with these people," referring to Phillips and others in charge of the ring crew. The details alleged by John Doe 4 follow a similar pattern to the other plaintiffs, so I'll be summarizing these paragraphs. Phillips brings Doe 4 and other ring boys or friends to WWE events, then some dinner or drinking, followed by inappropriate and forceful touching and assault with a little bit of clothing on that Phillips would call wrestling, and then, often enough, followed by more essay and abuse. Several of these incidents occurred in events in Pennsylvania. Phillips drove Doe 4 and his friends to WWE events in New York as well, and on one particular occasion, he got them intoxicated. They passed out, and the following day, John Doe 4 realized that he was essayed, and to the point of physical injury. In fact, a brother of one of John Doe's friends, confidential witness number 1, told the other sibling, their shared one, details of the incident, which are graphic and include multiple forms of essay. Doe 4 was transported by Phillips across state lines. After being transported across state lines, Doe 4 was subjected to the harassment and abuse described herein. Since Phillips' assault and harassment of him as a minor, Doe 4 has suffered from mental and emotional distress. E. John Doe 5. John Doe 5 was around 15 years old when he met Mel Phillips in approximately 1983 to 1984. Doe 5 met Phillips along with neighborhood friends who were also minors. Phillips frequently drove to the street where they all lived. He would pick them up, and then he would drive them around in Philadelphia. Doe 5 is the ring boy in the photo, this photo below, holding the tag team championship belt in Phillips' car. The following are 2 additional photos of Doe 5 working as ring boy. In the first, Doe 5 is backstage with a person working security and Ken Patera, a former wrestler with WWE, during several time periods, including 84 and 85. In the second photo, Doe 5 is next to the former WWE wrestler Tony Atlas. Phillips also took Doe 5 and his neighborhood friends to WWE shows at Nassau Coliseum in New York and at the Spectrum in Philadelphia. Doe 5 and his friends worked for Phillips on the ring crew at these events. Phillips also took Doe 5 to a WWE event at the Capitol Center in Landover, Maryland. After the event, Phillips plied Doe 5 and other boys with alcohol that Phillips kept in his car, and he got them drunk and took them to a local motel. One of John Doe 5's friends vomited from the alcohol. At the hotel, Doe 5 alleges in detail Phillips violently and inappropriately touching the boys, claiming it as wrestling with little clothing, and so on. Doe 5 took the following photo of his two neighborhood friends in a hotel room where they stayed with Phillips, with what appears to be a beer can to the left of the Coke can. Doe 5 was transported by Phillips across state lines. After being transported across state lines, Doe 5 was subjected to the harassment and the abuse described herein. Since Phillips' harassment and abuse of him as a minor, Doe 5 has suffered from mental and emotional distress. Parties. 4. A. Plaintiffs. John Doe number 1 is a citizen of Massachusetts. John Doe number 2 is a citizen of Massachusetts. John Doe number 3 is a citizen of Pennsylvania. John Doe number 4 is a citizen of Florida. John Doe number 5 is a citizen of Pennsylvania. Plaintiffs are using pseudonyms because of the highly personal nature of their victimization and because of the serious risk of harm to which they would be exposed if they brought this suit in their actual names. Defendants have tremendous wealth and power and have used it to retaliate against others who have attempted to come forward. Plaintiffs' safety, right to privacy, and personal security outweigh the public interest in their identification. Defendants use their power, wealth, and influence to control those around them. It is in the public's interest to give anonymity to abuse survivors so that other survivors may come forward and not be fearful that their identities will be publicized. Plaintiffs' legitimate concerns for privacy outweigh any prejudice to defendants or the public by allowing John Does 1 through 5 to proceed anonymously. B. Defendants. Defendant Vincent K. McMahon, a Connecticut citizen, co-founded WWE in 1980 and served on the board of directors for WWE from 1980 to September 2023. He was the executive chairman of the board of defendant TKO Group Holdings, Inc. until January 2024. And at that time, he resigned after allegations of trafficking and SA. Since then, he has been selling hundreds of millions of dollars worth of TKO stock. This complaint encompasses conduct that occurred in the 1970s through the early 90s, during which time McMahon was a citizen of Maryland and Connecticut and engaged in conduct in those states, which forms the basis of this complaint. Defendant Linda McMahon, a Connecticut citizen, is the wife of defendant Vincent K. McMahon and co-founder of WWE, where she worked as the president and later CEO from 1980 to 2009. Linda McMahon was also a resident of Maryland during part of her time period described herein. She was sometimes referred to as the co-chief executive. Defendant WWE is a Delaware limited liability company that operates as a division of TKO Group Holdings, Inc., TKO, a Delaware corporation. WWE's corporate headquarters is located at 707 Washington Boulevard, Stamford, Connecticut. On its website, WWE states the following: WWE is an integrated media organization and a recognized global leader in sports entertainment. The company consists of a portfolio of businesses that create and deliver original content 52 weeks a year to a global audience. WWE is committed to family-friendly entertainment on its television programming, premium live events, digital media, and publishing platforms. On September 12, 2023, a transaction completed between Endeavor Group Holdings and WWE resulted in a merger between WWE and Ultimate Fighting Championship, UFC, promotions and the formation of their new parent company, TKO. Defendant TKO Group Holdings, Inc. is a Delaware corporation that was formed for the purpose of facilitating the business combination of the WWE and the UFC businesses. Its corporate office is located in New York, New York. Defendant TKO was formed March 29, 2023 to be the parent company of WWE when the merger of the UFC was completed. TKO self-identifies as the following: TKO Group Holdings, Inc. is a premium sports and entertainment company that comprises UFC, the world's premier mixed martial arts organization, and WWE, an integrated media organization and the recognized global leader in sports entertainment. TKO is majority owned by Endeavor Group Holdings, Inc., a global sports and entertainment company. 5. Jurisdiction and venue. This court has jurisdiction pursuant to Maryland Code Courts and Judicial Proceedings 1-501, 4-401, and 4-402A because the amount in controversy is in excess of $30,000. There is a personal jurisdiction over defendants pursuant to Courts and Judicial Proceedings 6-103 because at all relevant times, defendant regularly transacted business in Maryland, contracted to provide services in Maryland, and caused tortious injury in Maryland. Venue is proper in this court under Maryland Code Courts and Judicial Proceedings 6-201, as no single venue is applicable to all defendants, but all may be sued in a county in which any of them could be sued, or in the county where the cause of action arose. A substantial part of the events giving rise to the plaintiff's claims occurred in Baltimore County. During the relevant time period, WWE shows were routinely held in Maryland, which was one of the company's key locations from the earliest days of the McMahon's ownership of the WWE, and each plaintiff was abused in Maryland. WWE routinely held shows in Baltimore, Maryland, and Landover, Maryland, during the relevant time period of this complaint. Maryland has a substantial issue in resolving the issues of child abuse that occurred within its borders, regardless of the citizenry or residence of the abused child or the alleged abusers. 6. Causes of action. First cause of action, negligence against all defendants. Plaintiffs incorporate and set forth all allegations above, as if fully set forth herein. Linda and Vince McMahon were co-founders of Modern Professional Wrestling and Professional Wrestling Promotion, the WWE. Together, Vince McMahon as the Iron Fist and Linda McMahon as his Velvet Glove took over the wrestling promotion industry and dominated it through consolidation and letting the fans in on the unspoken truth of professional wrestling. It was all scripted. WWE and TKO are the same entity and or a successor entity to WWF that existed at the time the plaintiffs were injured. As successor entities, WWE and TKO acquired any and all assets and liabilities for the entity WWF, and therefore are liable for the conduct of the principals, agents, and employees that occurred in the course and scope of their employment and or in furtherance of the WWF business and brand. The McMahons' rise to the top of this industry involved tremendous amounts of control and sharp elbows. The McMahons controlled and knew everything within WWE, including that the executives, Patterson and Garvin, and the prominent public-facing ring announcer, Phillips, were engaged in rampant misconduct. When the Ringboys scandal came to public light in the 1990s, WWE and the McMahons knew they had to take action to stop damage to the enterprise and to protect their interests at all costs, so they tried to deny their knowledge and underplay the allegations. Instead of taking action to protect the plaintiffs, as required by the general duty of all adults, Vince and Linda McMahon failed to act even though they knew or should have known of the risk of harassment and abuse that existed by their decision to employ Phillips, Patterson, and Garvin, who were known as having proclivities for underaged boys. WWE and the McMahons actively created an environment that allowed Phillips and others to bring minors into the WWE, including to work as part of the ring crew, whether there was a high risk and probability that they would be harassed or abused. The McMahons allowed Phillips to use the WWE and its assets to entice young boys to company events for defendants' benefit in growing their audience and prominence in the world of wrestling entertainment, and they failed to take action to prevent injuries to the Ringboys or report it on suspicion of injury. Plaintiffs met Phillips when they were minors under the age of 18. When a minor is employed, the employer has a duty to provide a reasonably safe place to work and warn of dangers. Adults who work in that environment have a duty to know and be aware of the safety of the environment and to warn children and their parents of safety risks. WWE and the McMahons had a general duty to exercise reasonable care to avoid foreseeable injuries to others, including the Ringboys. WWE and McMahon had a duty to report any unsafe conditions and not to exploit the Ringboys for their own personal gain. WWE and the McMahons had a duty to take affirmative action for the aid or protection of business invitees who are in danger on the business's premises because the WWE and the McMahons had knowledge of the danger posed by Phillips. WWE and the McMahons breached their duties by allowing Phillips, as their employer agent, to utilize the WWE to facilitate and further his penchant for abuse of underage boys. The WWE and the McMahons exercised control over Phillips, Patterson, and Garvin as employees and agents of the WWE. The WWE and the McMahons exercised control over the show venues and the ability of Phillips to bring underage boys in and out of the venue for the purposes of assisting with the ring setup, along with the ability to prohibit Phillips from using the private room before, during, and at shows, accessing free tickets, seating the Ringboys ringside, allowing Phillips to introduce the Ringboys to wrestlers at shows, and allowing Phillips to transport, recruit, feed, pay, employ, and provide lodging to underage boys before and after shows. Instead of exercising their control and authority over Phillips as an employee or an agent of WWE to prohibit him from having inappropriate contact with minors and or prohibiting him from using the WWE to traffic and harass and abuse the Ringboys, the McMahons allowed Phillips to utilize the WWE with impunity to satisfy his desires. The WWE and the McMahons knew that Phillips, Garvin, and Patterson employed underage boys for the purpose of setting up and taking down the wrestling rings in various venues and states. The WWE and the McMahons, either directly or indirectly, were providing Phillips with the funds and with the tickets that were necessary to provide payment, room and board, tickets, and transportation to and from the wrestling event, and other monetary benefit to the Ringboys as a method of compensation for the work they performed at WWE events in setting up and taking down the rings. The Ringboys received some direct financial remuneration for their work for WWE, but much of their payment was in the form of room and board, food, transportation, and free access to professional wrestling shows where they had opportunities to assist WWE and meet the wrestlers. The WWE and the McMahons allowed WWE employees, including executives, particularly Phillips, Patterson, and Garvin, to find, recruit, transport, and hire the Ringboys for their events. Throughout the employment of Phillips, Patterson, and Garvin by the WWE and McMahons, numerous allegations were made and commonly known within WWE that Phillips, Patterson, and or Garvin individually and or jointly engaged in behavior that would lead a reasonable person, employer, and contractor to believe or further inquire into the nature of relationship between Phillips, Patterson, and Garvin and the Ringboys, particularly Phillips's peculiar and unnatural interest in young boys. Mr. McMahon has never denied admitting his awareness of Phillips' interest, despite countless instances over the last 4 decades, where, if it were untrue, he would have stridently denied it. Vince and Linda McMahon, individually and in their capacity as the principals and the managers of the WWE, knew or should have known that Phillips had engaged in abuse of young boys under the age of 18, including the plaintiffs, who could not legally consent to engage in such behavior. Vince and Linda McMahon, individually and in their capacity as principals and managers of WWE, knew or should have known that Phillips transported underage boys, including the plaintiffs, across state lines for the purposes of engaging in business for and on behalf of the WWE. Vince and Linda McMahon individually and in their capacity as principals and managers of the WWE knew or should have known that the harassment and abuse was a systemic problem within WWE, including allegedly involving WWE executives and Vince McMahon himself. The WWF and its successor companies, WWE and TKO, and the McMahons had duties to protect the plaintiffs and other Ringboys from harassment and abuse by Phillips and others. Ensuring the safety of children is a duty and obligation shared by all citizens and organizations, including but not limited to reporting suspected child abuse. The WWF and its successor companies and the McMahons had a duty to provide the Ringboys with a safe place to work, free of harassment and abuse from their employees. It was foreseeable to the WWF and its successor companies and to the McMahons that Phillips and other individuals within the WWF enterprise would essay, molest, and or abuse plaintiffs and other Ringboys as well. Yet, defendants failed to take the action reasonably necessary to warn or protect the plaintiffs and other Ringboys from harm. Instead of exercising their control and authority over Phillips, Patterson, and Garvin as employees and agents of the WWF to prohibit them from having inappropriate contact with minors and or prohibiting them from using the WWF business enterprise to harass, abuse, and traffic plaintiffs and other Ringboys, the WWF and its successor companies and the McMahons allowed Phillips, Patterson, and Garvin to utilize their positions within the WWF with impunity to satisfy their desires, and particularly Phillips's peculiar and unnatural interest in young boys. As a result of defendants' failures and breaches to comply with their duties to protect minor children and provide a safe workplace, plaintiffs sustained actual and psychological injuries as a result of their harassment and abuse by WWE employees, particularly Phillips. Plaintiffs each sustained actual physical and mental injuries, lost wages, and benefits from employment, and suffered mental and emotional distress. As a direct and proximate cause of the conduct of defendants WWF and its successor companies, WWE and TKO, plaintiffs have lost wages and benefits, sustained damage to their reputations and careers, and suffered mental and emotional distress. Plaintiffs have been injured in an amount in excess of $30,000 and are entitled to judgment against all defendants for their illegal and wrongful conduct. Second cause of action, negligent hiring, training, and retention, and this is against all defendants. Plaintiffs incorporate and set forth all allegations above as if fully set forth herein. The WWE and the McMahons employed Phillips, Patterson, and Garvin for decades. Phillips, Patterson, and Garvin used their jobs to harass and abuse innocent persons, including Ringboys, which caused injuries to plaintiffs and other Ringboys. Defendants have a duty to hire staff at all levels to ensure that such management and staff does not create a risk of harm to the public, particularly minors. Defendants have a duty not to employ any person who they know or reasonably should know poses an unreasonable risk to other persons, particularly minors, who would foreseeably come into contact with that person because of the person's employment. Defendants hired, supervised, and retained Phillips despite the defendant's actual or constructive knowledge that Phillips was harassing and abusing plaintiffs and other Ringboys. For example, WWE and McMahons knew that Phillips had a peculiar and unnatural interest and attachment to children. They saw him going around with kids and both decided it was wrong. They temporarily fired Phillips for such conduct in 1988, but then rehired him merely 6 weeks later with the caveat that he steer clear of underage boys, stop hanging around kids, and stop chasing after kids. Phillips did not stop. In 1992, WWE and the McMahons temporarily fired Patterson when certain details of the Ringboy scandal became public, but he quickly returned. Defendants hired, supervised, and retained Phillips, Patterson, and Garvin despite defendants' actual or constructive knowledge that the WWE had a culture of systemic harassment and abuse that was fostered by Phillips, Patterson, Garvin, Vince McMahon, and others. It was reasonably foreseeable that Phillips, Patterson, and Garvin would injure plaintiffs and other Ringboys through harassment and abuse. Defendants failed to take any reasonable and appropriate action to protect the plaintiffs from harm by Phillips. Defendants breached their duties to protect minors, like the plaintiffs and other Ringboys, other employees or agents, and third parties from harassing and/or abusive conduct. Defendants failed to make a reasonable inquiry into the conduct of Phillips, Patterson, and Garvin to ascertain their fitness, particularly with respect to the interactions of underage boys before hiring, supervising, and retaining them. Defendants could not rely on Phillips, Patterson, and Garvin to protect or perform their employment duties without engaging in harassing and abusive conduct. Instead of exercising their control and authority over Phillips, Patterson, and Garvin as employees and agents of the WWE, to prohibit them from having inappropriate contact with minors and or prohibiting them from using the WWE business to harass, abuse, and traffic plaintiffs and other Ringboys, the WWF and its successor companies and the McMahons allowed Phillips, Patterson, and Garvin to utilize their positions within the WWE to impunity to satisfy their desires, particularly Phillips' peculiar and unnatural interest in young boys. Defendant acted negligently by hiring, supervising, and retaining Phillips, who proximately caused the plaintiff's injuries. The plaintiffs have sustained actual physical injuries as well as mental, lost wages and benefits of employment, and suffered emotional and mental distress. Plaintiffs have been injured in the amount in excess of $30,000 and are entitled to judgment against all defendants for their illegal and wrongful conduct. Wherefore, the plaintiffs demand judgment in their favor against the defendants in an amount in excess of $30,000 to be proven at trial for damages resulting from their conduct that led to the plaintiffs and other Ringboys being harassed and abused by the employees and actual or apparent agents of defendants. Plaintiffs further demand the right to a jury trial on these issues and for an award on their attorneys' fees and costs in the prosecution of this matter and any and all other relief that the court deems just and equitable. And it is signed by the attorneys, dated October 23rd, 2024. And that wraps up our 4-part series on the complaint brought by John Does 1 through 5, known as Ringboys, against Vince and Linda McMahon, WWE, and TKO Holdings. Thank you for joining me as we explored this complaint in its entirety. Whether you've been here since the first episode or you've just tuned in, I hope this series has provided valuable insight and information in this complex and troubling case. If you found this content informative, and if you'd like to see more of the same, then please like, subscribe, and hit the notification button to stay up to date on our latest releases. As always, stay informed, take care of yourself, and I'll see you next time on Mimi Leaks.